Recording in progress. And so my name is Mike Webb. My pronouns are they, them. I'm the public health policy strategist here at Equality Federation. Again, welcome. Feel free to introduce yourself if you haven't already by dropping your name and your pronouns in the chat, and feel free to include where you're coming from. We would love to know the geographic areas that folks are joining us from. Throughout the call, you can use the Q&A feature to ask questions, and we're going to also use the Q&A feature to make sure we're tracking and answering all questions. We'll run through a short agenda and make sure to take the questions at the end. But as all, I know many of us are about to get fired up by the amazing presenters that we're going to have today. And so always, per usual, feel free to drop any comments, any praise, any worship words that you have in response to the knowledge that we're going to learn today together in the chat. This is going to be a collective and a community experience, and we're going to make sure that you're part of it. The people we're going to hear from today, of course, we all know Mandisa Moore-O'Neal, the Executive Director for Center for HIV Law and Policy, who will discuss the Department of Justice and its history through a Black abolitionist lens. We also have Bianca, who have more degrees than I can count with one hand, but also is an award-winning educator, disability justice scholar, and curriculum writer, sexologist, which I'm very curious about right now, but that's a different topic for another day. And we'll talk about the history of the ADA, how ableism and stigma thrive together, and what the ADA offers. And then, of course, now we have the badass Kay Greenberg, the staff attorney at Center for HIV Law and Policy, will provide an explainer on the Department of Justice 11-page findings letter and talk about what comes next. How does that sound to folks? How does that sound? I know I'm excited to get started. Feel free to let me know what your thoughts are in the chat. And so I'm going to go straight to you, Mandisa. Can you explain what the Department of Justice is and what's its role with HIV advocacy?
Hey, y'all. First of all, I'm just so honored to be in this conversation. I'm honored when CHLP asked Mike immediately said yes. And when CHLP asked Bianca, she immediately said yes. So I'm excited to be in this conversation. As was mentioned, I'm Mandisa. My pronouns are she, her, hers, and I'm super stoked to have an overall conversation of what is the Department of Justice. It's a cautious advocacy tool. And the reason why I say that is going to become abundant. And I say this not to discourage us. It's a way of encouraging us to be clear who is this agency and the best ways to utilize them in the important work that we're involved in across the country. Next slide, please. And Katira Epps, also of CHLP, is holding down our slides. So as we see, this is a famous image that I imagine many people on this call know. Exactly, it's a picture of 6-year-old Ruby Bridges, who, if you're from New Orleans, you probably passed by France Elementary School several times. You might ask, what is she doing in a conversation about the Department of Justice? Those men who are escorting this child to and from school are an integral part of the DOJ. They are the U.S. Marshals, who are one of many federal law enforcement agencies that are under the DOJ. So again, there are these iconic pictures that we know from our civil rights history that actually the DOJ has played a part in. Next slide, please. Again, folks may know this also famous picture of James Meredith, who is the first person to integrate Ole Miss. Oh, sorry, Ruby Bridges was 1960. This was 1962, so really not that long ago. And again, he's being escorted to and from his college by U.S. Marshals again. So when we think of the DOJ, it's not only attorneys. Next slide, please. How frightened she was as a child doing the amazing work, and she still talks about it because she's still alive. So folks are in New Orleans. folks have probably seen like or heard of two things: safe streets, strong communities, grassroots organization that pre-Katrina and post-Katrina really pushed the US government to intervene on the NOPD and their multiple acts of civil rights violations against the people of New Orleans. And in 2012, what happened is the DOJ actually entered into a consent decree with the NOPD. It's important to highlight this story because I'm from New Orleans, so I like highlighting the histories of resistance in my own city. That's true. But also it points out two things. Many people are aware of the 2012 consent decree, which the Department of Justice played a huge role and still does in managing the decree and making sure that the NOPD is in alignment with what is outlined. Many folks don't know that in the 90s, what happened is the DOJ actually funded the NOPD in many of their justice grants. So let's talk about how an agency can simultaneously fund law enforcement and then 20 years later enter into a lawsuit based on the violations of that same law enforcement agency. That almost seems like a conundrum. And it makes you really wonder, what is the DOJ? Well, let's talk about it. Next slide, please. So as an overview, the DOJ has 3 missions, and it's the first thing that you see on their website. It is to uphold the rule of law, it's to keep our country safe, and to protect civil rights. That's really broad. So how they do that is in a few ways. First, there is a leader of the Department of Justice. That person is the US Attorney General. So some folks have heard of the 3 branches of the government. There is the legislative and judicial branch and the executive branch. The US Attorney General sits under the executive branch. He's actually a cabinet position, which means he reports directly to the president. Since 2021, our US Attorney General has been Merrick Garland. As you probably figured, with each president, this role changes. So even though the president is elected, the Attorney General position is not. Something to keep in mind. While not every person who works in the DOJ is a lawyer, it is important to know that if you are a lawyer for the DOJ, it is your role to enforce the interests of the federal government. And how they do that is in 8 subdivisions. One is antitrust, which is when corporations have a monopoly, civil, criminal, civil rights, environment and natural resources, justice management, national security, and tax. So for our purposes, what happened on December 1st actually happened under the civil rights division. And each division of the DOJ has an assistant attorney general. And for our purposes, the assistant attorney general of the civil rights division is Kristen Clark. Kristen Clark is the first woman who has ever served in the role of assistant AG of the civil rights division, which I find very odd, seeing as it's a civil rights division. But it is something to keep in mind, like when we think of who is in the positions. And within civil rights division, there are all these other subsection. Well, here's what's interesting about that. That's what they have on their website, that Kristen Clark is the first assistant attorney general of the civil rights division. That's different than Gupta, who's a US attorney general. So just putting that out there, that I'm talking about the assistant attorney general of this subdivision. And within the subdivision, you have the appellate, coordination and review, criminal section, disability rights, educational opportunities, employment, litigation, housing and civil enforcement, immigrant and employee rights, policy and strategy, special lit, and voting. So maybe some of these words, you know, have come to mind as you think of civil rights. And it is the purpose of the Division of Civil Rights to enforce federal statutes that are against the discrimination on basis of race, color, sex, disability, national origin, citizenship status, religion, and or familial status. Something else that's really important to know about the Department of Justice, as I mentioned, it's not just attorneys, it's also law enforcement agencies. So as I mentioned earlier in the pictures of Ruby Bridges and James Meredith, it's also the U.S. Marshals. It's also the FBI, which folks have heard of, the FBP, which is the Federal Bureau of Prisons, National Institute of Corrections, the ATF, many folks have heard of them, alcohol, tobacco, firearms, and actually explosives. I'm not sure why there's not an E there. DEA, again, we talk about the war on drugs. Drug Enforcement Agency played an integral role in that. And last is the OIG, Office of Inspector General. So this is an overview that is very helpful. And thank you for the person in the chat for pointing out something that actually comes up in a later slide about why it's important to engage in the conversation that we're having, is because what is the public facing information is different than the information that actually exists. So thank you for that. Next slide, please. So as we talk about the history of the DOJ, two dates really come to mind. First is 1789, but also 1870. So technically, the Office of the Attorney General started in 1789, which, if folks know, 1789 is also the start of the USA. So under the Office of the Attorney General, as you had the U.S. attorneys, these were the country's principal litigators. You also had the U.S. Marshals. And the role of the Office of the AG is to defend claims against the U.S. from various departments. Now, what's important about this is now all of that is handled by the DOJ, but at one time, various departments did it. So you might have a case of the Department of Treasury is involved. You might have a case that has attorneys in the Department of State. So it wasn't consolidated. But in 1870, it was so much post-Civil War litigation against the US government, it was a need to consolidate. Thinking of a critical race lens, what was happening post-Civil War to where so many people are suing the US government that they needed to consolidate? Many of the lawsuits came from former landowners in the South who lost their land because they were on the other side, on the Confederacy side, and so we're suing the US government to get that land back. So again, as we think of the role of enslavement and those who fought to keep enslavement and those who fought against it, it's really important to see how so many aspects of US history come from this. It's not really possible to divorce that, to the point they had to consolidate and make a department. And after 1870, all control of federal law enforcement fell under the DOJ. Also, all criminal prosecutions and civil suits of the US having an interest all came under the DOJ. So just a lens as to what's so important about 1870. Next slide, please. Now, as you could imagine, it was a lot that this new department had to undergo. And their first order of business was to make sure that the formerly enslaved folks had the rights that were promised them under the 13th Amendment, 14th Amendment, and 15th Amendment. And as a reminder, the 13th Amendment formally ended enslavement, except as a punishment for crime. 14th Amendment, it ensured equal protection under the law, and 15th Amendment, it ensured a right to vote regardless of race, color, or previous status as an enslaved person. And thinking of the social-political context of the post-Civil War US, but especially of the South, what happened in 1865, also in Tennessee, is the Klan was born, and terror was happening all across the region. So they had their hands full of trying to ensure that the folks who they promised, actually had a way of embodying the 13th, 14th, and 15th Amendment. So what we saw from the DOJ is they prosecuted a lot of Klan members. And as an example, here's some stats. In a 10-year period, roughly, it was over 3,000 indictments of Klan members and over 600 convictions. I think that is a pretty big deal in terms of what was happening. And, as we know, it didn't necessarily stop the tide, but it did send a message of at least one role of the DOJ, which is to prosecute those who are stopping others from enforcing their rights. DOJ was also doing other things. So we saw 1890, we saw the start of the antitrust division, which was important because of the era that I would say we're actually still in, of the robber barons who were exploiting people and had a lot of monopolies on their businesses. 1891 also saw the beginning of our federal prison system. And in 1908 saw what many people are very familiar with, which is the FBI, which again is a form of federal law enforcement. Then we're going to fast forward in the interest of time to 1957, which was the Civil Rights Act of 57 that saw the creation of the Civil Rights Division, which again is a huge part of the focus of this conversation. And then in 1960, there was another Civil Rights Act, and that one called for the federal oversight of local elections. Then in the 1964 Civil Rights Act, you see the establishment of the Community Relations Service. That's really important for our purposes because it was a body that was established as a way for the DOJ to interact with people in the community. Side note, everyone on this call is part of the community that the CRS has a part in engaging with. So please see yourself as a part of who the DOJ can engage on these things. And I hope that there will be more engagement. Then in 1968, we saw the first authorization of the Omnibus Crime Control Safe Streets Act. Again, thinking of the complex history from 1956 to 71, folks have probably heard of COINTELPRO, or the Counterintelligence Program. It was initiated by the FBI, and the purpose was to quash movement building, namely Black liberation work and anti-Vietnam War movement building. Again, I mention this, because it's important, for us to say and see that the same agency that has played a role in enforcing rights has also had a history of undermining work that is happening and rights as well. Next slide, please. Okay, now we're getting into more recent history. So in 1973, we see the establishment of the DEA, the Drug Enforcement Agency. And what's important with that is often seen as the start of the war on drugs, which many people on this call can talk in greater detail about how harmful it's been to Black folks, brown folks, people who are living with HIV, in a way that is still being unpacked. Although it was actually started under Nixon, President Nixon, it really became the beast that we know under Reagan. And we know this because in just a 4-year period in Reagan's first term, it went from an $8 million to a $95 million funded program. And we also saw a shift in penalties. So now you had expanded penalties for weed possession. Now you have a term that many of us know called mandatory minimums. So again, like we think of the DOJ and the different parts, it's important to think of that as well. Then in 83, we saw the EOIR, Executive Office for Immigration Review. In 84, this is especially pertinent for our purposes. And again, it goes back to the conversation earlier of New Orleans, the Office of Justice Programs, which partners with federal, state, local, tribal agencies, and national community-based and nonprofit organizations. And this is where a lot of funding has went to law enforcement agencies to increase their ability to police in many ways. In 94, we also saw the crime bill, which many folks know, again, is often seen as the marker or the start of mass incarceration as we know it. It provided 100,000 new police officers and allocated $9.7 billion for prisons and $6.1 billion in prevention programs. The last thing I will say in the interest of time is in 2006, we also saw SMART Office established, sex offender sentencing, monitoring, apprehending, registering, and tracking. Again, for the purposes of this conversation, that's really important to keep in mind because as Kay is definitely going to go into detail about, like, one of many harms of this law is the mandate to register as a sex offender. And again, it's a way to show how many of these things are connected. Next slide, and it's my last slide, I promise. So that's a history, and it begs the question, so Mandisa, how does the DOJ work? I get there are all these departments, some are lawyers, some are law enforcement agencies. So what happens? Well, it depends on the division that you're in. Some divisions, like the criminal division, it could start with a criminal prosecution. Many folks have probably seen in the news that our former President Trump and his many associates are in the midst of criminal prosecutions. Again, that is coming from the DOJ. Many folks on this call are also aware of the Braidwood case out of North Texas. That's a federal case, and the lawyers who are representing Becerra are Department of Justice lawyers. So again, there's so many ways that this work is connected specifically in the HIV work, and those who are doing work around like healthcare access. But sometimes it starts with a complaint letter. Kay is going to talk more about CHLP's work, but it is possible to file a complaint and like that, like file a complaint with the DOJ, like with the division. In CHLP's case, it was exactly a giant spider web. In CHLP's case, it was the civil rights division and then the disability rights subsection of the civil rights division. So like this, then like this. But it's really important to know that it always involves community members who identify a problem. So please see your work as advocates, as organizers, as really key in the work that is happening. As was mentioned, this is a 3-part series, and in other parts, it's going to go more in detail on how to file a complaint, you know, and the steps to do that. Does a letter make more sense, or all of that? So again, this was a gross overview. I hope it was informative as to what is the DOJ, and I hope it's not this mythical being, but something that makes a bit more sense now. Thank you.
Oh my God, Mandisa, thank you so much for that. I don't know about y'all, but I got a lot of needed background knowledge about the DOJ. I told y'all we have another, I need to stop cursing, but we have another explicit badass in the name of Dr. Bianca. I'm sorry, Bianca, how to pronounce your last name for me?
It's Laureano.
Laureano. Who's going to break down the ADA and how it's impacting people living with HIV.
Thank you so much, Mike. So I'm welcoming people in and I'm coming to you as a disabled person who is doing this work in community and also with people who are not in community. So I'll be talking to you about the ADA. And before we get to that part, I want to first talk about why do we even need the ADA? So Katara, let me know if you need me to share my screen. I'm happy to do that, to share the slides, and we can get started.
I'm gonna get your slides up right now.
Okay, great. So part of the ADA, which stands for the Americans with Disabilities Act, is complicated. And I'm also going to be offering like a critical overview of the ADA, and that's intentional. So if what you've heard about the ADA is that it's a great thing, we should celebrate it, yes, and we're going to talk a little bit more about why it's not enough and how we need to do better collectively. So the first part that I want to bring in is, why do we need the ADA? Like, what was happening? And as Mandisa shared around chattel enslavement, it's really important to recognize the connections between disability, chattel enslavement, and the way that Blackness has been weaponized to target people. That continues. I'll be happy to post an article if people want to learn a little bit more about a Black feminist disability framework offered to us by doctors Moya Bailey and Isaiah Mobley. All right, so the next slide offers us an overview of ugly laws. So prior to the ADA, there were what we call today ugly laws in the United States that were established. They started in around 1867, and several different states were implementing these statutes, these laws, these acts. And what they essentially were doing were targeting poor people, people who were disabled, as well as communities that were poor. So here we have an image from the Library of Congress, and it's called The Streets of New York, Running the Gauntlet of Horrors. And it shows a wealthy man and woman walking from church between lines of beggars, blind, crippled, and destitute. And this was really an attempt to create laws that say, we don't want to see these kind of people. We don't want to see disabled people, and we definitely don't want to see them begging for support or care or money. And one of the ways to do that was to say, you can't be out in public doing this, which means you can't be out in public, period. And it was a way to institutionalize us as well as criminalize us as disabled and poor community members. The next slide offers an overview of what was the language used at this time and also what shifted. So ugly laws really targeted us, as I shared, and it also identified disabled people as lazy. So this idea of capitalism, of being your labor being the one worthy thing that makes you useful and important to our society was definitely being played here. So the ideas of ugly weren't just about physical appearance. It was about definitely disfigurement and non-normative bodies, but it was also about being poor. And so this idea of calling us unsightly or disgusting, this was the language in the laws at that time. And what I equate this to, which might be a little bit more clear for some people, are what we would call today quality of life crimes. And quality of life crimes usually show up as things like graffiti, public urination, right? Things that people who are houseless or identify as homeless engage in or experience. And so criminalizing those populations in a really intentional way. And these quality of life crimes basically say, we shouldn't have to be exposed to that kind of thing. We shouldn't have to walk out of our beautiful homes and see graffiti on the mailbox. Ghastly, right? So this was also what I equate, if people need a clearer understanding of the ugly laws. And so ugly laws have been on the docket on state laws since 1974. Ohio as a state last repealed their ugly laws in 1972. Y'all, I'm 45 and I was born in 1978. Okay, so this was not very long ago. And when we talk a little bit more about the ADA, you're going to learn it wasn't very long after we had the ADA passed. So here we have an image of a picture from a freak show in the circus, because what ended up happening when disabled people were pushed out of society, some of the only places that we were able to be employed, find a livelihood, be able to move in the world was as circus sideshows or freak shows. So this is a really important component to understand, and why I'm using this image during our time together. There's complicated experiences with freak shows from a disability perspective. Some people are like, that is what we had to do to survive. It definitely is coming from a harm reduction understanding. And other people believe it was a form of exploitation. So there is no one consensus in disability community about the freak shows, but we all do understand that this was a form of objectification, exploitation, and deep, deep harm that still continues to follow us as disabled people, as circus and sideshows and human freaks in this particular way, using this particular language, has continued today. The next slide is an introduction to the ADA, because the first thing that we needed to have, as many of y'all know and have probably witnessed in a variety of different ways, is that movement needed to occur in order for an act to be created. So much like the civil rights laws that we have today, the movements that have been happening throughout the United States, that movement work led to the laws. So one of the things that occurred really in the 60s and 70s was the disability rights movement. And this movement offered a shift in the ways that disability was framed, but also in understanding the possibilities of what disabled people could do and also what we couldn't do. And trying to change that, and also wanting to create a different world. So the focus on the disability justice or disability rights movement was around accessing public spaces. So when we think about society, when we think about the ways that community members and disabled people are moving in the world, with ugly laws being present, we were removed, institutionalized, criminalized, incarcerated. And here the disability rights movement were fighting for us to have access to public space, to being present, to be able to go to the post office, to be able to get on a bus, to be able to get food at the grocery store, to be able to access public spaces, including like City Hall, which were not accessible to many of us. And it also had a goal in supporting independent living, where disabled people were like, you know what, we are not people that always need 24/7 care. Some of us do, and they should receive that care. And some of us need support a couple of hours a day, and others of us definitely need support in different ways, but we do not need to fully and always be monitored or surveilled in order to stay alive. And so the movement for pushing towards independent living was a really core component of the disability rights movement. It also focused on disabled people organizing, resisting, and changing laws that existed. Now, as you can imagine, the disability rights movement didn't get a lot of media attention. I mean, disability rights and disability needs are not getting a lot of media attention today. And we can notice that just with how long COVID is not being discussed in medical communities, the way that people aren't getting trainings. That's the whole thing we can talk about if people want to. But what I definitely want to bring in and remind us is that one of the ways that the disability rights movement did get attention in the 70s was when we had veterans who returned from war and were injured and impacted negatively and identified as disabled. And it wasn't until they came out in their wheelchairs and their crutches and their walkers with visible disabilities did media and news outlets pay attention. And so this is one of the ways that disability is a reminder that it impacts every community. Disability doesn't care how much money you make. Disability doesn't care what race you are. Disability doesn't care about your gender. It is going to show up in life. And if we're given the gift of aging, we are going to experience disability in some capacity. So here I have an image, which is from the photographer Kenneth Stein. They're disability buttons, and these are historical documentation of what it was like to wear these buttons. And so you'll notice some language such as handicap human rights, sign 504. The 504 was a law to make things public and accessible in a really particular way. And if you want to learn a little bit more about the disability rights movement, Qatar is going to put a few resources of curricula that I've written and discussion guides. I'll say a little bit more about those before I wrap up. But we don't use words like handicap anymore. And if you're wondering, why is Bianca using person first language or using identity first language? I will go back and forth from saying disabled person as well as people with disabilities. So in disability community, there isn't one agreement on what terms we want to use, but we all agree that we do not want to be called handicapped. We all agree that we do not want to be called people with special needs. Disabled is a word to use. It is not a bad word. It's not an ugly word. So I'm really here to advocate that disability is the word to use. And if you struggle with that, if you're feeling a little bit uncomfortable, if it feels weird, if you're like, well, I don't want to call my kiddo disabled, I'm gonna invite you to sit with that and consider why that's showing up for you. So the next slide is a little bit more about the impact of the disability rights as a movement. And so Qatar, if we can get to the next slide, thank you. So thinking about disability rights as a movement and its impact, this was an opportunity for creating the ADA and identifying disability as primarily a social condition. And what this means is that instead of targeting a person because of their body or their mind or the ways that they understand the world, we were looking at society as a whole and saying, you know what, it's society that has disabled individuals. It is our society that has made our spaces inaccessible to disabled people. It isn't hard to get someone who's using a wheelchair or someone who is blind or someone who needs a different kind of support access to the grocery store if we widen the doors or if we remove these poles that block people from getting in and out because we want to keep the grocery carts here, right? And those are really basic things. So if you enjoy a curb cut in the sidewalk, you need to thank the ADA, because it's not just about getting your laundry or pushing a buggy or a baby carriage. It was really created to make those sidewalks and public spaces accessible. So this focus of attitudes and barriers and society that really focused on the physical, the social, and the economic experiences were really an important way to bring up what is happening in society and how can we challenge that. And one of the things that this movement did was it introduced a conversation about ableism. And if you're like, what is that? I'll get to that in a minute. But one of the core things the disability rights movement also did was it invited us to think about what is debilitating. So it invited us to think about, if I can't get into the city hall because there's no door or elevator, there's only steps, is it my body that's the problem? Or is it the social body and the way that this organization or this architecture was created that I cannot access this building and my representatives or get access to due process, etc. So inviting us to think about what is debilitating. And things like war creates more disabled people. It is a debilitating act as well. The next slide, I just want to spend some time. I noticed that I did say the word ableism, so I'm going to offer a definition. And this definition comes from the organization Sins Invalid, which is the organization that introduced to us the disability justice framework. And I'll talk a little bit more about disability justice before I wrap up. But think about Sins Invalid the same way that we think about Sister Song, who introduced the reproductive justice framework. So Katara's put in the chat where you can find and purchase the Disability Justice Primer if you want to read a little bit more about this work. But ableism in that book is defined as the system of discriminatory practices and beliefs that maintain and perpetuate disability oppression, assigning inferior value or worth to people who have developmental, emotional, physical, or psychiatric disabilities. Ableism is racialized, it is gendered, it is heterosexist, and more. Ableism is utilized at the interpersonal level to the institutional and systemic level. So it really is embedded. Ableism is literally and figuratively in the air that we breathe, y'all. This is why we still have COVID thriving. This is why we have flu season, right? So the ways that people have access to things like vaccines or masks or information is also deeply rooted in ableism. The next slide invites us to think about the ADA. So after all of that movement, after a lot of work in the summer of 1990, there was an event called the Capitol Crawl, where many disabled people who use mobility devices left their mobility devices and crawled up the state, I can't remember the state, state stairs. And it was a really dramatic act, which really pushed the government officials to really start to introduce and take seriously Americans with Disabilities Act. So in 1990, the ADA was signed into law. It was celebrated as bipartisan, which means all of the two parties agreed that it should be signed. Here we have an image of the people who are present. You will probably notice there are 4 white men and 1 white woman. This was very core to what the disability rights movement represented. It was very much led by disabled white people who were using mobility devices, which is fine, but also exclusionary. And it didn't bring in all of the intersectional analysis and identities and understandings that we now bring in and want to talk about today. So this was under Bush Senior's tenure, and what the ADA agreed to offer and provide was equal access to things like employment and housing, but also to invite disabled people to have economic self-sufficiency, be able to work and be able to get some money and live a thriving life, and also to invite us to be able to fully participate in activities, especially in public spaces. So a lot of people usually hear about the ADA because they're like, this is inaccessible, or I have a 504 or an individualized education plan, or that's what allowed me to go to school and get the care that I needed, as well as the education that was required. But one of the things that we need to acknowledge, and I will say that I am alive today because of the ADA, let's be real, but also in 1990, we knew exactly who was dying from HIV-related illnesses and AIDS-related complications. And that community was overwhelmingly gay community, queer community, bisexual community. It was also people who were using or misusing drugs and narcotics, and it was also sex workers. And at this signing, the ADA did not include these communities as disabled people. It was a very limited act that was introduced, and it was very, very limited in who they were understanding and identifying as disabled. So I want us to acknowledge that this was intentional to exclude our communities in this way. This was a very conservative leadership at the time in this country, and very homophobic, very queerphobic, and very much into purity culture or shaming people for their sexual expression. The next slide invites us to keep all these pieces in mind. The Americans with Disabilities Act is a single issue identity-based act. It only looks at disability. That is it. It doesn't consider your gender, your class, your race, blah, blah, blah. Some people think that's great, but other people realize that does include all of us. It doesn't welcome all of us to be protected or cared for in a particular way. So when we only favor certain people to receive certain protections and certain rights, it's not really equal access, it's not really equal rights. So what eventually emerged was really a political strategy that relied on litigation, on being able to sue or fight in a discriminatory, fight the discrimination that was experienced by disabled people. Now, as many of y'all know, in order to fight in such a way, you need access to attorneys, you need access to fees, you need access to understanding these laws. And a lot of disabled people are not wealthy for a reason. And those reasons are going to be in the next slide. So the next slide shows a little bit more about the requirements for accessing the ADA and who was excluded. So many people excluded were people with autoimmune diseases. This is what HIV falls under when we're thinking about diseases and disabilities and quote unquote health. So it excluded people living positive with HIV. Deeply connected again to homophobia, queerphobia. I'm using the term slut shaming here, but we can also use purity culture if that's a little bit more easy on the ears. But also it supported the criminalization of us in very specific ways. So it was another example of upholding certain remnants of the ugly laws that we knew in the 1800s. But what this exclusion did is it helped reignite and push further a national harm reduction movement, which so many of us today have benefited from. And I can't speak more highly of harm reduction community, but if you're unfamiliar with harm reduction, I'm happy to put some links in the chat as well. For you to learn a little bit more, there's certain states that offer free training to the Department of Health around harm reduction. So it doesn't need to be something that you pay out of pocket for either. So this excluded many of us. And what ended up happening in 2008 was an amendment to the Americans with Disabilities Act. So the next slide shares what that amendment offered. So notice it was signed in 1990, and then this amendment came in 2008. I want y'all to do the math because I'm not good at math. Maybe it's 20 years, maybe it's not. Maybe it's almost 20 years. But this amendment finally in 2008 was when the ADA expanded its definition of disability, and that offered an opportunity for people living positive with HIV to be included and to be able to be protected under the Civil Rights Act of 1964, to be protected against discrimination, which they had definitely been experiencing. And so as many of us know, we lost entire generations of community members because of HIV and because of the way that this country was so deeply ableist and queerphobic and hated us. And so I just want to pause to acknowledge that in this moment. I know we pause a lot to think about like the people who have died in our communities, but I also want to pause and consider the way that our elected officials really did not care about disabled people, and they really did not care about people who are living with HIV. So as we think about that, I invite you to consider the reality that disabled people are also discriminatory. Yes, disability community has some insights and brilliance, but they're also human beings with their own biases and their own, discriminatory approaches. So one of the things that I think is really important to note and say here is that the disability rights movement has not been very welcoming to people living with HIV. And it has been a very contentious relationship that's been established and very complicated. And I can only think of one scholar, Chris Bell, who has written about the intersection of being disabled and experiencing a disability and also wanting to continue to engage in sexual expression. I'll put his name in the chat if people wanted to read a little bit more. He has since become an ancestor to us, but he is a Black scholar who is a Black disability scholar and a Black HIV scholar. One of the few people writing at those intersections. And this is a reminder of how deeply embedded disability community also is in things like purity culture and also in policing and surveilling other people's sexual expression. The next slide, and I just have a few more. This slide shares a reminder that the ADA is not enough. The ADA, as abortion advocates say, is the floor. So the ADA is the literal floor. It offers the basic kinds of protections. We're noticing this with long COVID and the way that the current US Census is attempting to redefine disability so that when they do the census and they understand disability, they don't see a spike of people who are surviving and living with long COVID. This is bananas, but that's what we're noticing. When we talk about marriage equality, this is a big thing in queer community, of which I am a part. There's no marriage equality for disabled people. We cannot get married if we are getting public benefits. We will lose those benefits, even if we marry another disabled person on public benefits. So here, the freedom to build our families, to love and care for one another is criminalized. It is something that we do not have equality around. We have a limited access to receiving public benefits. And if you know anything about conservatorships or guardianships, these are deeply, deeply another form of institutionalization for many of us. It is very much a violation. If anybody is looking at the news of what's happening, I believe it's Mississippi with Michael Orr, the football player, and how his white family members from the movie The Blind Side adopted him. They didn't adopt him. They put him in a conservatorship. And that judge was like, I've never seen anybody who is non-disabled be put in a conservatorship. Maybe you heard about conservatorships or guardianships because of Free Britney Spears. These are movements that are continuing to occur, and the young people in our communities are pushing us forward. So what I want to share as I wrap up, there's a couple other slides, so I'm going to move through these quickly, Katara. But the next slide is inviting you to consider what it means to define disability from a disability justice lens. We have not defined disability during this conversation, but what I want to invite to you is the reality that we are in another moment for movement. And this movement is a disability justice movement, where we understand justice not to be in the way that it is around litigation or how the criminal incarceration system talks about justice. We're talking about justice as defined within self-determination and collective liberation for all of us, not just disabled people. But within this lens, disability is understood not just as limitations or things that we cannot do or can do, but instead disability is a more expansive, liberatory understanding. It views disability as a lived, embodied experience, a political identity that is framed within the experiences of oppression called ableism. It is a community location from which we organize. It is also a political location that overlaps with all of our other identities. And it's also an aesthetic from which we practice, create culture through language, through fashion, through conversation, through what we create. And I want to leave you with the reality that disability needs to be about quality of life and not social control. So thank you all so much. I'm going to turn it back over to our facilitator, Mike, to introduce our next speaker.
Doctor, when I tell you, you broke down the ADA in a way that I've never seen before, I was like jotting down so many notes. Anyways, I'm sorry. Let's move on. We have very limited time. Thank you so much. And don't forget, everybody, put your loves, shower love and thoughts in the chat, but also drop some questions in the Q&A if you have any. We're gonna move right along to Kay. Come on, Kay. I know you have some final wisdom that we're gonna pull from you today.
Final wisdom, but those were some hard acts to follow. I was taking notes too. So yeah, so hi, my name is Kay Greenberg, pronouns are he, him. I'm a staff attorney at CHLP. And kind of my role here today is to just really kind of go through the nuts and bolts of what just went down in Tennessee. At this point, I have read and reread the DOJ letter 80 bajillion times. So that sometimes leads to maybe skipping things or not making anything clear. So if something I say doesn't make sense, please feel free to ask questions in the Q&A, and I'll try to get back to things later. So please do. I guess, can you hit to the next slide, Katara? Thank you. All right, so to start stepping through the history of what brought us here. So in 2018, CHLP started Team Attack, which stands for the ADA to Attack Criminalization. We were looking at working with a lot of other groups to try to develop creative legal strategies to overturn state HIV criminal exposure laws. So they try to look at the pros and cons of different legal strategies, the First Amendment, things like that, to see what they thought would be effective, and landed on the ADA, using the ADA as a tool to do this, which isn't something that's been done before, at least in this manner. So started looking into figuring out what states where the laws and the ways in which they're used and framed might make them particularly vulnerable to an attack under this. There was research done in about 12 or so states, and then working with a lot of really, so it's kind of looking at that, and then also CHLP coalitions all over the country, and Tennessee and Ohio had some really active, really amazing people on the ground doing some strong work and kind of that we were familiar with. So Tennessee and Ohio were kind of designated 2 states to test this out on. So we filed letters with the disability section of Civil Rights Division of the DOJ, asking them to investigate the statutes and see if they violated the Americans with Disabilities Act. And then on December 1st, 2023, the DOJ issued its findings letter for Tennessee. Something I'll get into a little bit, but keep in mind that this is called a findings letter, and I'll explain why I'm emphasizing that a little bit later on. Can you go to the next slide, please? So who did the DOJ investigate? So as Mandisa mentioned, the DOJ represents the federal government, and in this case, they investigated several different sections of the Tennessee government and the enforcement or executive branch of the Tennessee government, specifically looking at the state of Tennessee, the Attorney General, and current Governor Bill Lee. The reason why I put current because before all of these is some of these people, for example, weren't in office when some of the enforcement stuff happened, but they are now, and if they're involved in enforcing it, they're still violating the ADA. The Tennessee Bureau of Investigation, and the Shelby County District Attorney General's office. So the reason why the DOJ decided to focus on Shelby County is that they contain 74% of the total number of people on the sex offender registry for aggravated prostitution charges, which is what we're going to explain a little bit more later. And for example, in 2017 to 2022, they prosecuted 14 people. The entire rest of the state prosecuted 2. So it was chosen to focus on that county in particular, as well as looking at larger things. Because when we talk the statutes that we're talking about, they're state statutes. You can have local municipal codes and local regulations. We're not talking about that. Shelby County is not highlighted because of that, just because of the level of enforcement. So yeah, and Nathan, I will be getting to that. If we can, and as Mandisa said, you'll see a site to the Williams Institute in a little bit too. So what laws were addressed? So specifically, and just so you're aware, I'm going to be referring to things such as the sex offender registry, aggravated prostitution. These are not things that are people first language. These are not preferred things. In the context of talking about statutes and laws, I'm using the language that is in those. So I know that that might be triggering, but that is why, to keep it clear what I am referring to, why I'm going to be using that language. So one of the things I wanted to highlight on this is in 1991, aggravated prostitution was passed in Tennessee. You're going to find out that some of what caused the DOJ to make its decision has to do the fact that people convicted of aggravated prostitution are lifetime sex offender registrants. They were not made lifetime sex offender registrants until 2010. I just thought that that was an interesting fact to point out, that we were looking at 19 years of prosecution, and then we got to making people lifetime registrants. Can you go to the next slide, please? So what is aggravated prostitution? So aggravated prostitution, the statute is here. It's a person who commits aggravated prostitution when knowing that such a person is infected with HIV, the person engages in sexual activity as a business or as an inmate in the house of prostitution, or loiters in a public place for the purpose of being hired to engage in sexual activity. Some of the things that are important. So basically, in Tennessee, if you are working as a sex worker and are convicted of prostitution, that is a misdemeanor. If you are convicted living with HIV and working as a sex worker, that is a felony charge with a lifetime sex offender registrant. Something that is also really important to notice, and why I added emphasis in the statute, is loitering is included. The vast majority of the prosecutions in Memphis occurred with people who were picked up in undercover sting operations. So that means that people who were prosecuted under this law and placed on the sex offender registry might have never even physically interacted in any way, shape, or form with the person that they were engaged with, because it was an undercover cop. No, even if the person's not an undercover, like no physical contact is involved. It's not even that, there's not like that. So it is literally just criminalizing people on the basis of their serostatus, period. Not on the basis of any risk or anything any actual chance of transmission. It is just based on their serostatus only. If we can go to the next slide, please. And I'm sorry, I have the chat up to the side, and I can see that it's very robust. I'm not someone who can read the chat and talk about it while I go. So if any of this is questions, I apologize for not addressing them, and I promise I'll get to things in the Q&A. So who was impacted? So more than 90% of people who have been arrested for aggravated prostitution were Black. Which also factors into why Shelby County was focused in. It is the Blackest county in Tennessee and encompasses Memphis. 57% of the people who were forced to register were Black women. And again, as I mentioned earlier, 74% from Shelby County. And again, these facts are due to the work of Williams Institute and the work that they did working with people on the ground and interviewing and pulling data and facts and things like that to give us this kind of information. So obviously, and this is true of HIV criminalization laws writ large across the country, that they are typically enforced in a very racist manner, shockingly, like the rest of our criminal laws. So also pointing out who is impacted by the enforcement of these laws is also important. Can you go to the next slide, please? Okay, what is registration? So whenever I talk about the sex offender registry, I feel like it's important to take a moment to really emphasize the sex offender registry is not just a list. I think that there's a conception, there's this, people have heard of things like Megan's Law. They might have seen like a computer thing on a Google printout, which is harmful enough, that has people's information, like all of their biometric information, like name, where they live, their face, all of things like that. And I am not trying to minimize the stigma and all of the things by that. But the sex offender registry is much more than a list. It is this incredible, interweaving of all of these laws and regulations that basically incredibly constrict the lives of the people that are on it. And it has led to a growing movement in some areas that are organized by assault survivors and people like that, who are basically recognizing the ways that the sex offender registry does not actually make us safe. But for example, if you are on the sex offender registry in Tennessee, you have to report changing any registry requirement within 48 hours, such as moving, such as changing your shift at work, getting a new email address, changing your Instagram handle. Those are all things that need to be reported within a certain period of time, or you face felony penalties. It also constricts where you can live. It constricts access to watching your children grow up and being involved in important things in their lives. Tiffany Moore from Tennessee wrote in amazing article kind of detailing her experience as a registrant, and it's up on the body. It was also published December 1st, 2023. So if you want to get a real insight into what being a sex offender registrant means. And again, in Tennessee, with an aggravated prostitution conviction, you are a lifetime registrant. All right. If we can go to the next slide, please. So how does aggravated prostitution violate the ADA? So the DOJ found that the statute is a facial violation of the ADA. So first, just looking at the ADA itself, this is the text of the ADA. It basically means that, so no, on the basis of disability, you shouldn't be excluded from participation or denied the benefits of services, programs, or activities in a public space. For people living with HIV, HIV is covered under the ADA, both because its impact on people's access to daily life due to the impact it has on like kind of the medical situation and ability to access things for people living with HIV just based on the medical condition itself, but also it is also included based upon the stigma that people face, which is why, for example, your viral load does not impact whether or the level of physical things that are caused by that are related to having HIV. If you know it, regardless of where you are always covered by the ADA. I also think that's just worth pointing out. They said that it was a facial violation versus an as applied violation. So there's two ways in which statutes can violate the ADA and violate most anti-discrimination laws. One is facial, which is that it is specifically on the face of the law, like it is actually, the discrimination is included in the text of the law itself. As applied means that the ways in which it is actually, that it is used shows that the law is discriminatory, even if it's not actually written into the law and hypothetically not the purpose. And I say hypothetically, not the purpose of the law. Can we go to the next page, please? So this is the entire text explaining how aggravated prostitution violated the ADA. Basically, to summarize it, it said that they found facial discrimination because literally a sex worker who is living with HIV and a sex worker who is not living with HIV are treated incredibly different under the law in Tennessee. They also did a lot of emphasizing around the extreme addition of the penalty of being a lifetime sex offender registrant. So it is literally on the face, it is blanket, it is not individualized. Something that is looked at when determining whether or not a law violates the ADA is whether or not it allows for or calls for some sort of individualized interpretation or looking at case-by-case basis. In the case of aggravated prostitution, that doesn't exist. It is just a blanket law that makes a very clear distinction between people living with HIV and people not living with HIV. Can you go to the next slide, please? So the DOJ made a bunch of recommendations. Now, I'd said in the beginning that it was important to point out that these were findings. This isn't a court case. This isn't a law that was passed. This isn't something that, based upon finding that the law made these violations, that the DOJ can now go in and say, you must do this, 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 and this, period, the end, move on. What they can do is make recommendations, and those recommendations are what they think will bring the violators into a position in which they are no longer violating the ADA. These are also geared towards the executive branch of the Tennessee government, both at the county level and at the state level, because they can't order the legislative branch to pass certain things. They can only encourage that, for example, as you'll see in one of the recommendations of the governor, that certain things that people within the executive branch push for things to happen, and that gets into some of the separation of power issues. So what do the DOJ recommend? For the Shelby County District Attorney General's office, because again, we're looking at 74% of the people on the sex offender registry due to aggravated prostitution, that they cease enforcement, that they adopt policies forbidding discrimination against people living with HIV. That was writ large. That they take steps to rectify ongoing issues, because again, even if that these laws are still being enforced, there's because people who are forced to register before are continuing to be forced to register, and that they have to train all their staff and prosecutors on the non-discrimination requirements of the ADA, and also on any new policies that they pass to ameliorate these conditions. All right, next slide, please. Try and leave time for questions, so I'm sorry if I'm talking fast. So basically, what did the DOJ recommend? So to the governors and the Tennessee Bureau of Investigation, because the Tennessee Bureau of Investigation, again, is responsible for maintaining the sex offender registry, is to summarize, to cease enforcement, basically remove people from the registry, expunge all of their convictions, let everyone know who has been removed and had their record expunged, so they know that they no longer have this on their record, because as we know, criminal convictions impact things, everything from housing to employment to all kind of other rights and things like that. That they request that the legislature repeal aggravated prostitution, and also, and this is one of the powers of the ADA, and potentially, as we'll talk about in in our ongoing webinar series, pay compensatory damages. Violating the ADA is expensive, and it can be used, and that is potentially a tool that makes these findings powerful and persuasive to lawmakers. Can you go to the next slide, please? They also stated that they have to provide with written status reports delineating the steps that they've taken to comply with these requirements. So they need to be very explicit in what they are doing to comply. It's not just saying, yeah, we did it, and kind of moving on with their lives. So if we can go to the next slide. All right, so what's happened so far? So the short answer is I don't really have a satisfying answer for you. This is what that means. Under the letter, the Tennessee government had 15 days to respond. And by respond, they would either say, hey, you know what, we want to enter into negotiations for what's called a consent decree, meaning that both sides talk about what they think is what they agree, and they come to an agreement as to what should be done to come into alignment and what is enough to be in alignment, or B, if they don't respond or they don't come to an agreement, that the DOJ can sue them and bring them to court. The reason why, even though CHLP filed the complaints that we don't know the details, is the DOJ doesn't represent us. They represent the US government. They interviewed a lot of people, and in terms of putting together this report, they don't represent those people either. They represent the US government. So there are limitations on what kind of information is given out during the course of these negotiations and investigations and things like that. So the best information for what has happened so far was what I could find in an article by the Associated Press, which basically both the Shelby County District Attorney and Attorney General Jonathan Skrmetti said, so the Attorney General was like, I agree with their findings and we'll look to cooperate. And Skrmetti basically said that we look forward to finding out more and give them appropriate consideration, whatever appropriate consideration ends up meaning. So obviously they are aware of them and they are moving on them, but whether or not there's been conversations thus far, for example, is not information I can give anyone at this moment. If we can go to the next slide, I can tell you a little bit about what hasn't happened. So like I said, that these are findings. These are where the DOJ has found that these laws and the enforcement of these laws, because it's violate the ADA. They did not find, however, that the criminalization of people living with HIV general for under a criminal exposure statute in Tennessee, which was one of the laws that CHLP put in its complaint, they did not find that that violates the ADA in Tennessee. They did not, and again, they didn't find for CHLP for anyone convicted under aggravated prostitution. It's now between the DOJ and Tennessee, like I said with the last slide. The statute wasn't overturned or invalidated. As of right now, it's pretty much the status quo for everyone who had a prior conviction under, or and technically someone could be arrested and prosecuted tomorrow. At this point, it is the status quo. Tennessee is just on notice that any prior prosecutions and any future or ongoing prosecutions violate the ADA. And again, people on the sex offender registry still technically need to follow the requirements of the registration, or they can be found in violation. And again, violations are a felony that carry, depending upon how many violations you've had, a different amount of jail time for each violation. If we can go to the next slide. So potential impact of findings. So I included kind of the map that CHLP has showing the different kinds of criminal laws. So in the case, the DOJ decision is something that could have a lot of benefits and positive things for people living with HIV. Again, violating the ADA is expensive. It is a tool for leverage, and a tool for leverage that can be used for advocacy. Also, just because the DOJ did not find in Tennessee that the Tennessee law criminal exposure law violates the ADA, that doesn't necessarily mean that any of these other exposure laws around the country, especially again, because there's also as applied and facial, could necessarily be found to be in violation. So it shows that there is traction for these ADA complaints, because this has not been a tool that's been used before, and it really gives advocates and activists leverage. And if you can go to the next slide, and if you want to learn more about it, save the date for Tuesday, February 27th. We're hoping to do the next webinar in the series, where we'll go more into the implications and start the conversation about some strategies and tools for people working on the ground who want to utilize this. And now, I guess, updated map coming soon, because Tennessee did remove lifetime registration recently for people criminalized under exposure. So that is, I think, wrong on this current map. So that said, I hope I left some time for questions.
You touched on this a little bit, Kay, and thank you. Everybody shower Kay, Professor Kay, some praise in the chat if you can. That was equally informative as chapter 1 and chapter 2 of our webinar today. I've never understood these findings as much as I do now, and it's thanks to the combination of all three of you, Mandisa, Bianca, and Kay. We do have one question. You answered this a little bit, Kay, but I just want to make sure that we hit it directly on the head. How can other states possibly model a path with their county DA offices or finding around aggravated prostitution, or what options are there for states to model this action?
I can start. So Thank you for that question. I think that's also like the hope of part 2 is like to dig down, and then part 3. Here's what comes to mind is a couple of things. One, states don't have to wait for an ADA findings letter in order to do the work of fixing their criminal statutes. You know, like I know on this call, folks are organizing now. So please don't think, oh, well, I have to wait for that. Like, this can put states on notice. And the reason why is because I know Kay mentioned this. It's important to say again, in the letter, the DOJ said, you know, if, you know, a tenancy doesn't answer or doesn't do the things in a period of time, it is possible that the state is going to be sued. That is costly. So I think that that's one tool for engaging with other states. It is expensive to violate these laws, and some states need to know just how expensive. So I think that that is something that is important to keep in mind. And I think it looks differently. So some states have an aggravated prostitution statute very similar to Tennessee's. I think that their advocacy path is going to be a very different one than those that have HIV criminal statutes like that are written different, or like don't focus on sex work per se. But I definitely see this as a tool that any state can use, you know, as a way to engage with their lawmakers on this issue.
My God, I love that. And I think that sounds about right. And it also sounds like a lot of folks that, you know, it sounds like data and storytelling was critical towards helping pushing this forward. And I know a lot of states are already working on that. I know that's all the recorded questions that we received from folks. I'm giving one last chance. But I know we had 3 different chapters of encyclopedia level knowledge dropped on us. And so we're probably still processing. I know I'm ready for webinar number 2, implications of the findings. Save the date, February 27th on a Tuesday in the new year, bringing closing out Black History Month in a very powerful way. I think that's it for us. Any final words, Mandisa, Bianca, Kay?
I just thank everybody for attending. Mike, for your amazing moderation. Bianca and Kay. Oh, there's one more question. Sorry.
Yeah, this just dropped. The administration transition in 2024 is weighing heavily on some of us. How would this impact the strategy of filing, strategy of the findings from the DOJ? Potentially, how would a different president could impact the trajectory of this?
I think it's something to always be mindful of, because like as mentioned, while the president is elected, the OU's attorney general is appointed, by that president. So it's something like to keep in mind, and it should be a part of the strategy. I also think that it's some other factors to consider as well, because even if you start something, it doesn't necessarily mean that it would be finished in a period of time. So I don't think that because a potentially a very likely hostile person would come in, that is a reason not to. I think that there are some other factors to consider, but it's always important to be mindful of that.
Thank you for that. I almost called you President Moore-O'Neal.
Oh no.
One last question that might close us out, and I think this is goes great to that personal experience and importance of people who have lived experience. Is there any opinion whatsoever on those of us charged with aggravated prostitution to seek a personal civil rights attorney? And Emily, drop your question in the chat if the Q&A not working for you.
Hey, it looked like you were coming off mute.
So with the Jeopardy buzzer, I'm like starting to go, but I feel like I'm still deciding. I mean, I think honestly, knowing what's going on and knowing your options, because again, with this, you're technically not a party to it. So talking to someone to see in if your specific situation there are options is always a good idea, but you know, I'm a lawyer and I answer when we don't 100% know the answer to a specific question is ask another lawyer. So you can also take that with a grain of salt.
I like that response. And then I think the final question, thanks to Emily, is are there any other things that are connected to the AP, like violations that are not related to zero status?
No, the thing that I cut and paste there is literally the aggravated prostitution is on the basis of zero status only.
Thank you for that clarification. And I agree with you, Stephen Williams. President Mandisa Moore-O'Neal sounds great to me as well. Well, that sounds great, and I love to close it on that. And so I look forward to seeing all these beautiful and amazing people February 27th. Thank you, Bianca. Thank you, Kate. Thank you, Team CHLP. Y'all rock this.